All right. Ladies and gentlemen, I've got it as 1 minute after 11. We've got two bills before us today. We've got House Bill 225 by Representative Reinders, and we've got House Bill 413 by Representative Hatfield. I think most people here are familiar with both of the pieces of legislation. Representative Reinders, I'm going to allow you to present House Bill 225. And
Here, Mr. Chairman.
Right there.
Thank you so much, Mr. Chairman, members of the committee. I appreciate all the work you've done in perfecting this simple piece of legislation. Again, the intent, obviously, is to decrease any potential voter fraud and being active in terms of proactive in terms of making sure that the people of Georgia are the ones most involved in the decision-making process of registering people to vote. The simple substitute working off of LC 284733S is provided, however, that voter registration drives shall be conducted only by persons who are legal residents of the state. We had some concerns originally that perhaps some underage or the age requirement or age limits may do something that might actually hurt the bill or discourage people from taking part in the process, and I appreciate your efforts on this and ask for your approval.
Thank you, Chairman Reinders. Are there any questions from members of the committee? Representative Thomas Moore.
Thank you, Mr. Chair. I think it's important as a member of the subcommittee to make sure all the rest of the members of this committee understand that I, along with I think most of the members on the subcommittee, had real problems with this bill. I appreciate the author making some changes, but I still want to be very clear that I think it's problematic. I wonder if it's even constitutional, and I know that doesn't stop us from passing bills sometimes. But my concern, again, is that we are trying to restrict who does voter registration in our state. If I were to go to Florida, where I'm from originally, and want to register members of my family to vote, I don't think that should be illegal. I'm not trying to impact an election in Florida, but I'm simply trying to register my family members. And I find it problematic that we would take a move in this committee and pass this bill out if that's what members plan to do. Well, we would restrict, I think, what is a right and even our responsibility as citizens to try to register people to vote and get them involved in this political process. Lastly, I want to point out, Mr. Chair, that I think it's important, with all due respect, that when we left the subcommittee with this bill, it was not moved on because it had so many problems, and it was agreed that the author of this bill was going to come and work on the real issue, which is fraud, and this bill still does not address the issue. And I also have a problem with the process itself and how this bill was moved out of subcommittee. It was not voted on, but something that was done by the chairman. And I do have great respect for you, Mr. Chairman, but I don't think that was a proper way to pass this bill out. And I think if it had the merits that it needed to have to pass out of this committee, it wouldn't have had to be passed that way.
Thank you for those comments. The bill was moved by signature of the chair with no recommendation from the subcommittee, but I would suggest that the bill is very much different today. The original bill, and there were other concerns as well, but one of the primary concerns was that a 17-year-old Georgia resident under the original legislation would not have been able to participate in a drive, and this does allow any Georgia resident to participate in the drive. I respect you and your opinion on the procedure and understand that, but I do hope we can move this bill forward today. Representative Powell, I think, had a question.
Yeah, I just want to make sure it was the right Powell. Representative Reinders, the part that was added, which is provided, however, that voter registration drives shall be conducted only by persons who are legal residents of the state. In your opinion, does this, if you've got an organized voter registration program and the bill provides that the information necessary to do or an organized voter registration program can be given to private entities, National, League of Women Voters, or whatever it may be. Is it up to that organization to provide that everybody that participates in the voter registration drive is a legal resident, or is it up to the individual volunteer to know what the law is and say, oh, I can't participate in this because I'm from another state or I'm not a legal resident of the state of Georgia? I guess my question is that as you envision this, who's going to be responsible for making sure that only legal residents participate in voter registration drives? Is it the organization or the individual or both or what?
Well, I would assume that any organization that is going to organize itself for the purposes of going into to another state, we've heard about that this past election, should be aware of what the rules and the laws are in regards to each state that they choose to operate in. So therefore, I would feel like it certainly would be their responsibility. And in being the attorney you are, you know the old ignorance of the law is no excuse. So,
right. But primarily, you would think that the organization itself would be responsible for making sure that everybody that participated was legally authorized to participate.
I would think they should know that.
All right. My second question is, from an enforcement mechanism, what are the consequences? I mean, are the ballots thrown out, the registrations thrown out, people thrown in jail? I mean, I don't see a criminal sanction here, and I guess my question is, it's nice to have this in here, but what are the consequences?
Thank you so much for the questions. My understanding, and I'm going back from memory now, is that it would be nothing more than a misdemeanor, and I think already covered in code section would be up to a $1,000 fine.
Okay.
Thank you for the question.
Representative Floyd.
Well, I would just had wanted to ask you to go over the bill with me, but since I mashed my light, you've explained it a little bit and so forth. But I really still don't see a need for the bill. I think if you're a citizen of the United States and you're trying to get some people to vote, I think that's all it should take. But.
Thank you.
Representative Powell.
This is the other member of the Powell caucus. As I read it, on the face of it, I didn't have a problem as I was looking at it, but then I asked counsel about it, and according to him, this means that all people participating had to be a Georgia resident. Would you consider maybe that the person in charge of a voter registration drive, that someone would be designated as a Georgia resident, as opposed to you might have for instance, a national campaign?
I thank you so much for that question, and I think it undermines the intent. The intent is the organizations and groups that send dozens and hundreds of people into to have one person designate over all of those. I think that would be, frankly, impractical. I think it would usurp the intent, which is people trying to come in and manipulate the process. But thank you for the question.
Representative Chambers.
Mr. Chairman, I believe this is a question more for you or for Legislative Council. If we implement this change in law, will we need to get Department of Justice approval for this change?
I do believe that the bill would go before the Justice Department, if that answers your question.
Thank you.
I think Representative O'Neill.
Thank you, Mr. Chairman. I'm sorry I came a little bit late, but I'm maybe addressing the author, but also probably Legislative Council. I think the word conducted is a huge issue here. And even from a nonpartisan standpoint, we know for sure there are two major political parties and then several others in this country. They have central U.S. offices in different places. I'm guessing Washington, D.C. That both of those parties that we're very aware of are constantly conducting voter drives or encouraging them. Now, whether or not the conducting of them means the provision of the forms within the geographic boundaries of a state? Or I get my question to the author is, what do you mean in the context of this language by the word conducted? Give me a definition of that verb, please.
I can't give you that definition of a verb as drawn up by legislative council. I left it up to their expert opinion that this was the best way of doing it. What I'm trying to do here, Mr. Chairman, I thank you so much for the question. What I'm trying to do is to keep the people coming in from outside the state that have no interest. We talk about local control all the time, that have no interest in the politics and the running of the state, but are certainly coming in and signing up, as you recall in the press, the Dallas Cowboy football players and things of this nature. They need to have a vested interest in what is the best interest of this particular state and not some other kind of agenda out there. And that's what I'm really trying to do here, is just to be simplistic with the answer.
Does that answer your question, Chairman?
No.
Not even close, but that's about all I was going to say.
Thank you.
Representative Meadows. All right. The bill has been moved. Is there a second? Second. All right. Bill's been moved and seconded. Representative Powell.
I would like to propose an amendment to the substitute.
Representative Powell, I'm sorry, but I'm not going to recognize amendments at this time. If you have something, and I'll be happy to work with you. I know the author's been willing to work with people on amendments, and try to address that in rules if possible. But I promise you, I will. If it's consistent with the intent of the legislation, we'll try to work with you on it. I apologize. Bills have been properly moved and seconded. All of those in favor, please signify by raising your right hand. All opposed, same sign. 64. The Bills and the Rules Committee.
Thank you, Mr. Chairman, members of the committee.
Thank you. Representative Hatfield.
Thank you, Mr. Chairman. I come before you today to present House Bill 413. This is a continuation of a hearing that we started last week. When I got to looking at the law on residency of local officials, particularly with regard to city managers, county managers, and department heads. And I did not know this, but once I started researching the issue, I found there's a statute on the books right now that was passed in 1975 that says that no city or county can require as a condition of employment that its officers or employees reside within that city or county. And my concern comes about because a couple of things. One, I believe that the city managers and county managers play a major role in determining or helping to determine what the millage rate is going to be for their locality. They make recommendations and participate in the process by which commissioners decide millage rates, and so they are effectively participating in deciding how much local residents are going to be taxed. Additionally, not only city managers and county managers, but also those people who are department heads and many times appointed officials will be in charge or overseeing the expenditure of taxpayer dollars. And again, they are in effect making decisions on how local residents' money, tax money, is going to be spent. Because of that, I am proposing HB 413. It has changed from its original version, but I have a substitute in the folders, which is LC 284715S. When this came through subcommittee, the subcommittee voted to basically just strike the statute in its entirety, which would give local governments the authority to require any officers or employees to live within the city or county as applicable. There have been some concerns stated by groups such as police officers, firefighters, ambulance personnel, and my intent has never been to deal with the average city or county employee, but to give local governments an option to require people in a managerial capacity to live within the boundaries. And so the substitute that I reference leaves the statute on the books, but it provides an exception for city managers, county managers, or officials appointed by the governing authority of a municipality, county, or consolidated government, and for department heads of municipalities, counties, or consolidated governments, as those positions are defined by a local act or ordinance. And this way, the local governments will each have the option. There's no requirement that they make employees, their department heads or managers live within the city or county. But if it's appropriate on the local level, they will have the authority to be able to make that requirement. And I've heard it suggested as an argument that this is going to limit the pool of applicants that would be available to fill a position. Well, actually, that's not true at all. If a city or county decides to require residency, they're not limited to looking within the city or county for an employee. They can look anywhere. But when they go to hire someone, they can tell them, if you want this job, that you're going to live within our boundaries. The whole point of this is that I believe, as a matter of principle, that if a city or county manager, for example, is helping to set millage rates on local citizens, but that city or county manager does not live in the locality, they are making decisions essentially to tax local people, but they will not be in the same position as those people that they're managing. And if they live in another locality, there's always the possibility they're even paying a lower millage rate in an adjoining county or in whatever city or jurisdiction they may live. So this basically, for lack of a better term, I believe that this puts or gives city, county managers, and department heads some skin in the game, so that when they make decisions on behalf of local residents, they'll be situated the same as the local residents, but only if local government decides that that's something that's appropriate for that locality. So, Mr. Chairman, with that, I'd ask for the committee's favorable consideration of the substitute to HB 413.
Any questions from the members of the committee? Representative Meadows.
Representative Hatfield, I'm going to give you a situation. You tell me if I can hire my independent school system. Got a school board. We hire a superintendent, and he puts the budget together. He brings it back to the school board. To the school board, and then they bring it to the city council. He lives about 400 yards in another county. Could we not hire him?
This bill would not apply to school districts. It only applies to cities and counties, because that's what the current law applies to actual a municipality or a county as defined under our current law. So school districts would not. It wouldn't affect them one way or another.
Even though he's probably the one person that sets that budget for the tax because we talked about tax purposes and millages. Right. Even though he's the one person that really does that.
Well, as I said, under the terms of the bill as it is right now and the law as it is right now, it does not affect school boards. So I would presume that right now a school board would be free to either require or not require their superintendent to live within the jurisdiction. In other words, there are restraints now in place that apply to cities and counties, but those are the only governmental entities that the restraints apply to. So this bill would not have any impact on school districts one way or another.
All right, we've got several questions. I think Chairman O'Neill was the first.
Thank you, Mr. Chairman. And this may piggyback on that. I'm just curious from the gentleman, officials appointed by the governing authority, that's pretty broad. Could that be interpreted to mean just everybody? What do you mean in that
No,
particular
I think
phrase?
there's a definitional section in the code, and I don't have it on the tip of my tongue, but there is a provision in the code that deals with appointed officials and defines those who are serving under an appointment as opposed to as an employment relationship. I certainly, I think the appointed officials would get at things like city or county attorneys, those people who are appointed to serve on various authorities of local government. I had a discussion with Representative Powell about that particular aspect of it, and I would defer to the will of the committee on that. I think, though, that in as much as there are appointed officials who will have an input into expenditure of taxpayer funds, that they really ought to be included. But the thrust of my intention here is to deal with the inability to require a city or county manager or department head to live in the jurisdiction.
Follow up, Mr. Chairman, and you segued into what my real question was. So there is, as far as you know, then a distinction in the code between employed and appointed?
Yes, sir. I believe that is correct.
Okay.
I'm sorry I don't have the code section to give you.
We have several other questions. I think Representative Chambers was next.
Representative Hatfield, so I just want to go back and let you know that I preferred the original version where we just struck code and, let cities, counties, consolidated governments make their own rules, publish them, and do their own bylaws. Is there any chance that you would be willing to go back to what we had out of subcommittee where we just struck the language?
I will defer to the will of the committee on that. I thought that was probably a good way to approach it, but I'd also sense that there's opposition amongst the ranks of, as I said, police officers, EMS personnel, et cetera, because there is a fear that local government may come in and say, well, all employees have to live within the jurisdiction, and that may or may not be a good thing. I really think we ought to trust the local governments to make those decisions that are most appropriate for them. And you would assume that a local government, if they felt like they could not get a sufficient staff by requiring them to live in the jurisdiction, that they would not impose that requirement on themselves. But I'll defer to the will of the committee. The reason I prepared the substitute was because I do know that there was some opposition from those groups that represent various groups of employees, and it's not, my intention was not to deal or not to focus this on the rank and file employee, but people in a managerial capacity.
Yeah, well, the reason I asked that, Representative Hatfield, is the LC number 4635S, which is striking the code section.
Right.
That's very easy to understand.
Right.
I'm sorry, but I'm just having a hard time comprehending 4715S
Well, it is.
in a way that would make it easy for city attorneys to be able to go in there and figure that out so they can advise their city councils. And quite frankly, wouldn't the city council have to answer to the people if, if they went in and they fired the whole police and fire department or something?
Sure.
I mean, I certainly wouldn't want to face election after doing something that crazy.
Well, I agree with you.
And so I think that would be incentive enough to, if the author's willing, and the chairman's willing, maybe to go back to our original substitute on this.
Well, again, I would defer to the will of the committee. I think that that your point's well taken, and it is kind of a difficult concept to get your mind around because most people, and including myself, did not know that there was a provision in the code that said that a city or county couldn't require an officer or employee to live in that jurisdiction. I think most everyone would assume that they would have that authority, but I think that this was passed. This statute was passed back in 1975, and I think it was, from what I've been able to learn, that it had to do with the city of Atlanta, and the city of Atlanta wanting employees to live within the boundaries of the city of Atlanta. But certainly not every jurisdiction is the same, and what may work for one jurisdiction may not work for another. And this just, I think, would give some flexibility, whether you do it through the version that I've submitted through the substitute, or if you do it in the way that it came out of subcommittee. Either way, there would be more flexibility granted to local governments to make their own decisions.
Representative Powell.
I would disagree with Representative Chambers as far as striking the whole legislation. Representative Chambers, you'd be surprised how provincial some folks can be sometimes. And but following up on Chairman O'Neill's question, dealing with officials appointed, to make it clear, would you have a problem with something to the effect of non-employee appointees by the governing authority, or something to make it clear that it was not an exception that swallowed the rule type thing?
I wouldn't have a problem with that. I think you could simply say on line 17 where it says or officials, you could say or non-employee officials appointed. Mm-hmm. I think that would make it clear. And I do appreciate Representative Powell, your discussions with me in helping to refine this legislation.
That's fine.
Representative Hatfield.
You mean
I'm
Hamilton?
sorry, Hamilton.
It never ends, does
I've
it?
heard Hatfield talk so much today, it's
No.
just ringing in the back of my mind.
It never
We'll
ends.
answer to either one.
That's right.
Mr.
That's right.
Chairman.
Thank you, Mr. Chairman. Representative Hatfield.
Thank you.
Sorry about coming in late. I just want to clarify something because you may have covered it. Let me paint a scenario also just to make sure I understand. This is allowing the local government to make that determination on those positions. So, for example, if my city manager does not live within the city, this says the city has the ability to require that the city manager live within the city, but we're not forcing that upon them. Is that correct?
That is correct.
So, in essence, we truly are giving the authority for the city or county the ability to make those requirements on the specified positions or appointments here. That just want to make sure I'm clear on that.
That's correct, Representative.
Because in the original, or it came to me that case in point where I had a city manager that does not live with the boundaries of that city. And his quote to me, if this passes, then looks like I'm going to go ahead and retire. You're giving me the assurance that's not the case unless that municipality determined that was necessary.
That's correct. And I will sort of amplify on that a little bit by saying this. And I know that, I've seen some speculation that says, oh, well, Representative Hatfield's got somebody a city or county manager that he's trying to get rid of or something like that. We do have, our city manager in Waycross lives inside the city, but our county manager for Ware County lives over in Brantley County. And that's something that I know has been discussed amongst citizenry about the fact that the county manager would live in the next county over and pay a lower millage rate over there than what is being put on our citizens. However, I want to stress that this, the legislation is not about any one particular person or individual. There's a provision in the state constitution that says that you cannot impair obligations of contract through new legislation. And so, like, for example, in our community, both the city and county managers are under contract with the local government, and those would not be affected, nor would any other local government officials that are under a contract, an existing contract.
Okay. Follow-up question, Mr. Chairman. What about a development authority? Does this, going back to what Chairman O'Neill was asking, would members of a development authority be covered under this right here?
I would think that it would depend, and I would defer to legislative counsel if he has something to add, but I think it would depend on how the development authority was structured and how its appointments were determined or how its officers were determined. If the development authority were subject to have its members appointed by local government, city or county, then I think that under the language of the substitute that city or county could require that the members that they appoint live within the jurisdiction. Is that, Mr. Lanier? Yes. Okay.
One follow, hopefully just one more. Tell me about, you're the learned at the council, I'm not. Tell me about existing contracts, existing situations, and what happens if there's not a contract, where we currently have a sitting city manager, and if the city determines that they want to implement a new policy to make that requirement, how is that handled in the eyes of this code here?
Well, I think the answer to that is that if there's not an existing contract, then I presume that as Georgia's an at-will employment state, that city manager or county manager, as the case may be, would be an at-will employee and could be let go for any reason or for no reason, as long as it's not some illegal reason like a civil rights concern or something of that nature. But the answer is, if they don't have an existing contract, I think their city or county commission could impose a requirement that city or county manager live in the jurisdiction. But I really don't make very much of that because, as I said, Georgia's an at-will employment state, and so if they wanted to just get rid of a city or county manager that's not under contract, I think they're free to do it at any time.
All right, thank you.
Yeah, Mr. Chairman, if I may, to address some of the comments that were made by Representative Hamilton, my personal opinion, and maybe somewhat based in law, is that county managers...
Representative Powell, would you tell everybody what your position was in the past and where your experience comes from?
I was city attorney I was city mayor for the city of Camilla for 12 years. And president of Georgia Municipal Association a couple of years ago.
Thank you. I just wanted people to know
that
you had experience in this area.
City managers and county managers, by and large, serve at the pleasure of the governing authority. And I think that, and as a matter of fact, every city manager that we had during my tenure as mayor, we had a contract with them that conditioned their employment upon them being residents of the city of Camilla. And as a result, I don't really think that the current law applies to those managers anyway, because they can be terminated at any time, if the governing authority changes as a result of an election, and it happens quite frequently. I really think that the only people that this is going to affect that are not affected now, it just clarifies the other issues, is the department heads. appointed officials, by and large, like development authorities, they are going to be governed. If it's a constitutional authority, they're going to be governed by the constitutional amendment that created it. Statutory development authorities, I think, already require that whatever entity, whether it's a county or a city, forms a statutory authority, that authority members have to be a resident of whatever jurisdiction creates it. Because I know that we looked at it specifically as to whether we could appoint city development authority members who had a business interest but were not residents of the city, and we could not, and that was state law, I think. So anyway, development authorities, housing authorities, all of those basically require residency already. City and county managers, I don't think, are covered by this, but this would clarify that they are not. And appointed officials such as the city judge, municipal court judge, city attorney, I think that's a matter of policy because they are not employees, but this would clarify that. So I really think the only people that would actually be brought under the umbrella of this that are now not brought under it would be department heads. And that's just a policy issue as to whether you want to do that, because if department heads submit their departmental budgets to the city manager and then the millage rate is based on that, there may be some policy reason that you want them to have some skin in the game, but each individual local government would be able to choose whether they wanted to do this. It doesn't mandate anything, it just gives them the option.
Any further questions from the members of the committee? All right. Representative Powell, I know that you were going to recommend an amendment. Let me ask this. Is there a motion on the bill? Moved. All right. The bill's been properly moved. Is there a second? All right. Bill's been moved and seconded. Representative Powell, do you want to offer your amendment to insert the words non-employee in front of the word officials on line 17? Yes, sir. All right. Is there a second to that amendment? All right. Amendment's been properly moved and seconded. All those in favor of inserting the words non-employee and from the words officials, please signify by saying aye. Aye. Any opposed, same sign. All right. We have before us LC 284715S as amended. The bill's been properly moved and seconded. All those in favor do pass. Please signify by saying aye. Aye. Any opposed, same sign. No. You want a hand count on it, Mayor Moore? All right. All those in favor of the motion do pass. Please raise your right hand. All those opposed, same sign. Bill is passed. It's in the Rules Committee. Thank you for coming.